Court does call the case, People State of Michigan versus James Whitley.
This is a continuation of a case from yesterday. The judge delayed it to today so that his decision was not made in anger. The defense attorney made a direct attack at the judge's integrity, and Judge Simpson made sure he didn't make that mistake again. Watch yesterday's case at the link at the top right corner.
Your Honor, for the record, my name is Jeffrey Dunn. I'm very glad to have Mr. Whitley stand to the right. Sir, please state your name.
James Thomas Whitley.
This is a continuation of the hearing. Is there anything additional from the people?
Nothing additional from the people.
Anything additional from the defense?
Nothing. Yes, Your Honor. One thing additional is that if the court finds that money bail is necessary, I believe that based on this case, an appropriate bail would be something like a $10,000. The current bond conditions regarding specifically a GPS tether with the exclusion zone and the drug and alcohol testing, I think, address what the primary concerns are in the report. He was intoxicated, and of course he should not be around here. But the reason I think primarily that the $150,000 surety bond was excessive is he has no history of any violence whatsoever. In fact,
well, can I just stop you there, because I have some concerns about the representations of what happened that were made to the magistrate at the time, and some of them made to me yesterday. I went back and listened to the arraignment, and my understanding is that the alleged victim in this case contacted the defendant to pick her up from Chelsea bowling lanes or something along those lines.
he went to Chelsea Lanes to make sure she got home safe because she was intoxicated.
Right. And then after that is when this ensued. I'm having difficulty. Well, let's put it this way. According to what I have, he shouldn't have been driving. That's number one.
Well, he wasn't tested. The allegation is that he was intoxicated. I don't believe he agrees with that characterization.
Mr. Bennett, do you know what you said at that hearing regarding intoxication? Well, first of all, I don't think there are two issues there. One, he wasn't supposed to, my understanding is his license is revoked with restrictions, and that his activities in going there that night would not have been within his restrictions on his license.
Okay.
Right? Secondly, with regard to the incident, the indication is he was trying to get his keys to then drive again, which would have been outside of his restrictions on his license. And there was at least the indication when there was a talk of intoxication that the defendant at that time may be intoxicated.
I believe I said exactly that. He may have been intoxicated. Can I address that concern or not?
Go ahead.
Your Honor, if that's the concern is that he was driving when this happened, then an added condition that we can't be driving without a valid license.
No. My problem is with the whole story. Because why is he getting his keys to drive when he's not supposed to be driving? Is what I'm having difficulty even understanding the offenses you're telling me they may have existed at that time.
She was intoxicated at Chelsea Lanes. He wanted to try to drive her home. She refused. She drove her cell phone. I haven't seen the alcohol test. I don't know whether or not she passed or not. He followed her home to make sure she got there okay. The parties he had generally, I believe, according to the report, it's spent most nights there. Then they got into an argument and he tried to leave, couldn't find his keys, and that's when the incident with the bed, the phone, and the glass break began. I think, in my opinion, those sort of discrepancies are only, I guess, the absolute truth, I guess, would be relevant to bond, but they decrease the likelihood of conviction when you have the alleged victim saying that her statements weren't entirely accurate, and wishing to recant, and him saying he was looking out for her. When the argument got loud, he had asked her to keep it down so her children wouldn't hear them arguing, because he was concerned about trauma they experienced from a prior abusive relationship. And telling her to calm down actually escalated the fight, and that's when the incident happened in the bedroom, which there's a disagreement about what that was. That, at the end of the day, resulted in the injuries that were sustained by the alleged victim to her wrists, our arms, and a head. I would clear up, since you gave me a chance. There were actually, I believe the people said there were 3 CAT scans, there were 4, there were 3 x-rays. I was able to do what they provided. But I think that the key issue in this bond is somebody who is a close friend, the alleged victim, has known Mr. Whitley for 20 years and said he's not violent, that this has never happened. So, regardless of whether or not there's a conviction for purposes of bond, he does not pose.
Well, if I consider him a danger, yes. I mean, what I've got here is I've got somebody that shouldn't be driving, who may have been intoxicated, who would have driven on 2 occasions when he's not supposed to be driving, in violation of his restricted license, breaking the law. Then I have this confusion about the incident. I don't even know why she would have his keys if it now, as you're relating to me, that he drove and then followed her, which was not the indication that I got from listening to the arraignment. And then an altercation occurs that results in what I would consider significant injuries to the alleged victim in this case, to the point of a level of medical care that was required regarding that person, which I think would have been significant. And then from that, does she have to keep moving? And then, it creates in this court's mind a level of potential danger that this individual poses, potentially to the victim as well as to the community. It certainly raises that level. because he's not this law-abiding person that you say he is, because he's obviously driving. I mean, he's got those previous convictions, which led to the revocation of his license, which led to the restriction, and he's violating that twice that night, at least. So, I don't know. Sparoso, was there something else?
No, you're right.
Anything else, Mr. Bennett? Anything else, sir?
No, I just don't know. I get that he was driving when he's violating this restriction. That doesn't warrant $180,000. I do think that some cash bond is appropriate. This one. I think it should be something that policy. Especially in case that the likely sentence is probation.
Understood. And what I am additionally indicating is that in listening to what was the representations at the arraignment regarding what transpired, listening to what transpired that day, hearing what is today, it's unclear to me that that's what actually happened. Because that's not what's been said on the defense side about how this whole thing comes about. I then end up with an individual that is severely injured where they're at the hospital getting the treatment that they're getting. There's some indication that that's her fault. Maybe. But then, and that the defendant is trying to get away. I just find that version of events, it may indeed be true, but I find it, at least at this point, to be sort of remarkable that that would be it. The court, go ahead. What were you going to say?
I was just going to say that sounds like testimony.
Oh, I'm sure it certainly will, but I don't have that at this. It normally would during a bond hearing. I have to assess it based upon what I see, and I would say also, with all due respect to the magistrate of this court, that making a statement of giving a PR, but then indicating that the people might file an emergency bond motion, how she'd know that, I do not know. But that, from my perspective, leads the court to believe that it was in part of the court's funding, but also as a result of what the court is looking at in this case, would find that her decision to issue a PR bond was indeed an abuse of discretion in issuing that bond. The court will leave all of the conditions that she set in place. I will set the defendant's bond in the amount of $35,000 cash surety. Defendant Remanded.
Thank you, Your Honor.
Go one. All right. Court stands at recess. Thank you.
All rise.
Do you think the judge made the right call? I think so. Yesterday, he was victim blaming, and today he minimizes everything his defendant did. I know that is his job, but no one should consider victim blaming as a tool in their bag. If you can't defend your client without it, you have a bad client. Figure it out or prepare for jail. Put your thoughts in the comments and don't forget to like, subscribe and share. It's free and helps the mission of adding more accountability to the courts. The more public they are, the more they know their actions will be seen. Education is an essential aspect of freedom.